Hi everyone, welcome from Law with Dunk the Law Guy, and today is day 58 of the Case a Day series journey covering cases across criminal law, tort law, contract law and the English legal system. If you ever have a case you want me to cover, pop it in the comments section and I'll get round to it. Please be aware that the case recordings are available on TikTok, YouTube, Instagram, Facebook, Twitter and on Spotify too. Simply search Law with Dunk the Law Guy or at Dunk the Law Guy. And to law teachers and students who may prefer an electronic copy instead to read from, so far I've uploaded both PDF and Word document versions of Actus Reus, Causation and Mens Rea handouts to my shop on test.com, which I hope will help you should you want these. The shop is called the Law Guy _ Law Library Shop. Once launched, I'll be uploading these to my website too, which will be called thelawguy.co.uk. Today, I'd like to cover the case of Tuberville v Savage 1669. This case is important because it provides a situation where a defendant's words may contradict and therefore deny any potential threatening action from the defendant, leading to there being no assault being capable of being committed upon the victim. This is known as how words can negate an assault. This legal principle is only allowed to apply if the words are clear enough to indicate that the defendant was not intending to harm the victim, which may otherwise be interpreted from the defendant's actions. In this case, the defendant, Tuberville, became angry after some insulting comments were made towards him by Savage, and so Tuberville responded by placing his hand on his sword hilt, or handle, which may be deemed to be a threatening action, as it could go on to cause a person to fear/expect an attack. However, the defendant, Tuberville, then went on to state the famous words of, "If it were not for a size time, I would not take such language." These words meant that he was not going to use his sword because the criminal judges were in town for court sessions, i.e. assize time, or the court of assizes or assizes, which I don't pretend to know much about, but I think this was with the aim of helping to standardize the law across the country, with visiting judges from the London higher courts travelling from region to region across the country to hear local court cases in the main county towns. And so the defendant's words here indicated that he was not going to attack, and thus his words negated an assault. And that's it for today. Thank you from Law with Dunk, the Law Guy.